Thank you very much indeed, Joanne. It's a real pleasure to be here. It's an absolute honor to be addressing this conference. It's one that I've watched myself, and it's a great pleasure to be here. The only problem is I'm following Mark. So it's kind of like following the Rolling Stones. I have to come on and try and give something a little bit more valuable. He's produced pages and pages of beautiful photos and imagery and evoking the spirit of space. I've got pages of densely packed legislation for you. And what I'm going to do is I'm going to try and take you through a little bit of a different view of the way in which space law works. My view is very much that actually space law should be invisible. It shouldn't be something that we should see. It should just operate underneath the existing structures. And that's why I've got the theme today of collaboration and competition, because in essence, I see those two issues as the crux of space going forward and managing space governance over the next 10 years. We need to be aware that without collaboration, none of this happens. We've already seen some amazing work. We've already had some brilliant discussions. It was a pleasure to see my good friend, Professor Karen Olsen-Francis there, talking about the work of astrobiology OU, again, bringing in collaborative work and making governance part of the discussion. And in the first years when I was doing this, I often felt like I was going around pleading and saying, can we have a piece of the pie? But now I think very much the community is open to discussion and to collaboration, realizing that actually one of the biggest obstacles isn't necessarily the tech. It isn't necessarily the engineering. It isn't necessarily the ideas. It's the permissions. It's making it work and making the collaborations work. So I would encourage you to start thinking of space law, space policy, space regulation as actually the oil that lubricates the whole system of collaboration and that makes this all possible. And what we've got is a context. I'm going to talk briefly about the UK regulatory context. We're going to talk about some of the key issues that I think are going to be of interest. The movement from the UK Space Agency, from being this dual role of regulator and cheerleader, to very much looking at it as a rallying point and as a point to generate the interest, and then handing over some of their regulatory duties to the Civil Aviation Authority. I think this is a good thing, because I think, again, to hark back, and I am going to hammer these things throughout the presentation, so I apologize, this isn't going to be subtle, to talk about collaboration, using the strengths of the CAA, the safety aspect, the engagement with the development early on to ensure that the space applications are safe, that they're lawful, and that they actually do the job that they want to do. And one of the things that I always try and talk about, I always try and give a little bit of space law advice throughout my presentations. The first bit of advice I'm going to give is early engagement with the regulators, I think, really makes a difference down the line. The earlier that you engage, the more chance of successful approval for your mission that you have. I think, again, collaboration between regulators is going to be an increasing feature of space governance moving forward. We've got spectrum and radio frequency issues that are needed to be dealt with. I think spectrum is going to become another one of those areas that is, to borrow a phrase from the military, is going to be increasingly congested and competitive. So we're going to see this tripartite arrangement of regulators with the Space Agency, with the Civil Aviation Authority, and with Ofcom. I think as well, we're going to see a change in our collaborative relationship with the European Space Agency. Mark brilliantly outlined the advantages and why being part of a bigger collaborative venture is so crucial to the UK's position within the global space economy. But we know that there are pressures outside. We know that there are political dynamics at play here as well. This is something we're going to have to keep an eye on to make sure that the politics doesn't bleed into the relationship. I think as well, there are going to be increasing governance challenges. And in a minute, I'm going to talk a little bit about the Outer Space Treaty. Of course, that's sort of the tools of my trade, but I'm going to give a slightly different perspective on it, because I think going forward, we're going to have some strains on making that what the American administrator Jim Bridenstine called operational, the operationalization of the Outer Space Treaty. It very much has resided in the sphere of academic speculation, but I think with the missions that Mark was talking about, you know, the missions to the moon, the sample return missions from Mars, we're going to see the contours of the Outer Space Treaty really develop. And I think we also need to be honest about the gaps in capacity. It was Miles Davis, the jazz trumpeter, who said, you know, it's often not the notes we play, it's the notes we don't play that make the performance. And I think that's something that we really have to be mindful of. There is some tremendous work going on, but what are the gaps in capacity that UK space can fill? I think, and again, this is me editorializing, you may feel differently, but the collaborations that I've engaged with Northern Space and Security shows that there is a real deficit of information about the orbital environment. If we're going to effectively regulate it, and if we're going to effectively manage it, we can't have too much information. And I think that's an area that we really need to look at. So I'm going to talk a little bit now about the Outer Space Treaty, but I'm going to present it in the form of a pyramid. And what we see from that pyramid is what I call the top tier of space law. This is where the Outer Space Treaty lives. It's the very rarefied atmosphere of these general principles. And sitting kind of underneath all of that, one of the questions Mark asked me in the green room was about the Artemis Accords. You know, where do they all fit in? How does it work? And there are a huge array of non-legal, non-sort of binding mechanisms that nevertheless feed into the way in which space is governed and feed in crucially to the decisions made by regulators. And that's where I think the area of movement is. I don't think, again, I'm giving you my opinion here, please feel free to disagree, listen to other experts, but my opinion is we won't see too much movement on the Outer Space Treaty, and actually, nor should we see any movement on the Outer Space Treaty. It's fixed, and if we start unpicking it, we may not get that level of consensus that we have at the minute. So I've talked about sort of the discussion that we're going to have. I'm not going to go into too much more detail about this, because I think really what we need to think about is, why does the Outer Space Treaty do what it does? Why is it so important? And when we're thinking about regulation and when we're thinking about the collaborations, we need to think what it is we're doing. And the space agency, the reason the space agency regulates the way it does is because of the treaty obligations that are in the Outer Space Treaty. And when we look at those treaty obligations, and I've highlighted some of the key phrases there for you, the international responsibility for national space activity, whether it's carried out by government agencies or non-governmental entities, authorization, continuing supervision, and national space agencies having responsibility to ensure compliance with the Outer Space Treaty. That's why regulation looks the shape it does. That's why we have to have this series of permissions and this licensing regime. And so that's the way we find that state obligations are satisfied. They're satisfied by means of a licensing regime overseen by a regulator. Now, in the UK, we've got two separate regimes, one of which is active and has been established for a number of years, and I have to say has been brilliantly dealt with by the UK Space Agency, given the challenges that the Outer Space Treaty regime places. We've got the Outer Space Act. Now, the Outer Space Act is an old piece of space legislation. When you look around the globe, most sort of nations don't really have legislation that goes back as far as this, but it's a good old-fashioned licensing mechanism. And this deals with space activity that occurs outside the UK. And it's specifically in the legislation now that this looks at outside the UK, because inside the UK, we have a whole new way of regulating what they call space activities. That's suborbital activities, activities that go, you know, across the boundary of airspace and outer space. And that activity is dealt with by the Space Industry Act 2018. And again, that's regulated by the Civil Aviation Authority. So again, here's the promise. I did promise you densely packed legislation. Here it is. But essentially what we've got here is the traditional regulatory framework that the UK Space Agency has managed. And right at the bottom of the screen there, you'll notice the way that it's given teeth. One of the criticisms you often hear is that there's no enforcement mechanisms in outer space. Well, there is, but it's on a national level. It relies on national regulators. Remember, I talked about Article 6 of the Outer Space Treaty, international responsibility for national space activities. This is where we see it, the creation of an offence of unlicensed space activity. And the granting of a license is a discretionary one. There is no right to have a license. It's granted at the discretion of the Secretary of State, and the Secretary of State takes advice from the regulators as to whether the mission is going to cause problems in relation to safety. Is it going to cause problems in relation to the international commitments? Is it going to cause problems in respect of national security? So what we see there is a regulatory regime that's designed to be flexible, designed to take account of the needs, the individual needs of the mission. There are various other requirements under the Outer Space Act that I won't go into too much detail, but suffice to say there's conditions in place. There's a significant amount of conditions that can be placed. There's the requirement of registration, and there's a whole range of enforcement mechanisms that the regulator can impose. So thinking about the biggest problem facing UK space regulation, and it's not a problem unique to the UK, it's the question of liability. What happens if something goes wrong? This is where collaboration gives way to competition, because we then see, okay, who's going to be liable if something goes wrong? And there's broad, with the international framework is explicit, but it's very broad in its detail. We've got Article 7 of the Outer Space Treaty, and we've got the Liability Convention, which imposes it on launching states. Launching states under Article 7, different from the state of authorization under Article 6. But I think what we've got is a real issue here of how are we going to collaborate with the insurance industry? How are we going to make it so that we can see that, insurance, finance, regulation, industry, science, and technology can all work together? And so I think what we have to do is we have to collaborate in respect of not just the notes we can see, not just the obvious connections between Company A and Company B, or academic institution A and academic institution B, but really, and again, going back to the outreach work that Mark is doing, look into society, look deeply into society and say, how can we make space work for us? How can we have the regulators being informed by these non-binding guidelines? How do we comply with our international obligations? And I think as well, if I were to look at some of the key issues that I see coming up on the horizon in space governance, it's not with the regulatory framework. It's not with the Outer Space Treaty. What it is, it's with the way in which these become operational. I think we're going to have to be a lot more flexible in the way that we regulate these missions, because the technology is always going to outstrip the law. I was going to talk a little bit about the Space Industry Act. I'm looking at the time, and I've already given you several pages of densely packed text, so I won't do that. Instead, what I'll do is say that it broadly follows the contours of the Outer Space Act, and I think that's kind of one of the problems. We don't really know how to do licensing, and we don't really know how to do liability yet. We haven't really got the insurance right, and we haven't really got that ready. In terms of managing the problems that we see in outer space, debris management. I'm doing some work, I'm very proud to be working with Astroscale on looking at learning lessons from the nuclear industry, the oil and gas industry, about decommissioning assets. There's a whole rich regulatory framework there. But again, to go back to my message, we can't regulate if we don't have sufficient information. So I think that's an area that we need to look at as well. Space surveillance and SST is going to be a crucial element of understanding exactly how we manage going forward. And I finished rather early, but I'm going to pass back over to Joanne now for any questions you might have.
very much, Christopher. Fascinating. You brought what could be considered as a bit of a dry subject really to life, which is brilliant and explained so clearly. You mentioned about ways to take the regulation as things become operational, and you highlighted that you're working with one of the Harwell Space Cluster companies, Astroscale. I wonder if you could talk a little bit more about that interplay between regulation and companies. And for everybody else, please make sure you put your Q&A in the box.
Absolutely. And it's funny enough because it was at the IAC last year where myself and Harriet Brettel started talking about how we need to look outside the pre-existing silos. And I think it takes people of vision to do that. And one of the great things that I've certainly found working in the space industry is that we're not short of people with vision. We've got some amazing people to work with and people who will take that leap of faith. I don't know if it's peculiar to the space industry. I have a hunch it is. My colleagues in other areas of law seem to be having, some very sterile debates, whereas one of the great things I'm finding here is the ability of the space industry, perhaps because it is not as mature as other areas of law, perhaps because there is that developmental area and, we're all sort of learning it together, that I think we have this ability to try and influence change. So I found companies are willing to collaborate. I found regulators very open to discussion as well. And as I said, that early engagement coupled with a desire to make the thing work really sort of helps.
The key answer is communication, isn't it, between all parties?
Absolutely, yes, much more articulately than I could have done.
So one of the questions coming in, what common misconceptions do people have around this topic, and how do you suggest we combat these?
Thank you very much. That is a wonderful question, because I think one of the things we need to sort of try and get our heads around is the different ways of what I call governance. I'm professor of space law, but actually I'm really more professor of space governance. Law is an aspect of that, but it's not the totality of it. The Outer Space Treaty, again, often criticized for not having enforcement mechanism. That wasn't its job. The job of the Outer Space Treaty was to lay down some very basic principles that we could all agree on, we could all coalesce our activity around. And then we have what I call the accountability triangle in the middle of it, of Article 6, which gives international responsibility to nations, Article 7, which endows liability, and Article 8, which incentivizes registration. So that's its job. Its job isn't to be a police officer of outer space. The nations are meant to police their own space activity. And I think that's kind of the thing as well. And sort of rolled into that guidelines, and I often hear the 25-year rule bandied around for the post-mission disposal. It's not a rule, it's a recommendation, but it can be made a rule if domestic regulators require it as part of the licensing process. So it's actually quite a subtle interplay between all these different dimensions.
Excellent. Right, we've got quite a few questions, so we'll try and do them quick fire if we can. And just following on from that, has there ever been a successful prosecution for an activity in space?
No, and I think one of the reasons why is because the Outer Space Treaty deals on a state level. And once you get state-to-state litigation in any form, it becomes time-consuming, it becomes expensive, and everybody shrugs the shoulders and says, look, why don't we just settle this out of court? And that's kind of one of the problems I have, because I love precedent. I love seeing what happened in cases before, and we don't have that just because it was too expensive.
Okay, and following on from a point that Graham Turnock made this morning, how do you engage and balance society's interests in space versus industry, i.e. the impact of constellations versus ground-based astronomy in the night sky?
This is one of the things that the law does. It is a huge balancing act. We have on the one hand safety, and on the other hand innovation. We have the desire to get as much information as we can from space, but we also need to have ground-based astronomy. And I think that's the balancing act. And I don't think there's a one-size-fits-all for this. I think this is why having a regulator that's flexible and that's amenable to ambient changes in technology, but also is aware that there is a wider picture, that's going to be the crucial aspect. This is one of the things, again, to go back, the UK Space Agency, I think, does really well, because it doesn't try a race to the bottom. It isn't just grabbing industry money. It does try to take account of the bigger environmental picture.
Excellent. Thanks very much, Christopher. Unfortunately, there were more questions, but we haven't managed to answer them. But hopefully you'll get a chance to catch up with Christopher in the networking zone and can catch him to find out the answers to your questions.